Hello, I'm Payal Chawla and welcome to my podcast Navigating Commercial Disputes, brought to you in partnership with Bar and Bench. In this podcast, I aim to break down complex commercial issues for lawyers, for law students, and legal enthusiasts alike. The draft Arbitration and Conciliation Amendment Bill 2024 has recently been released by the Department of Legal Affairs, inviting public comments. The bill proposes extensive changes to the Arbitration and Conciliation Act 1996, aimed at transforming India's arbitration framework. At the outset, conciliation will be removed from the Act, including from both the long and short titles. If the bill passes muster and becomes an Act, the legislation will be known as the Arbitration Act 1996. For interim relief under Section 9, court will only be able to intervene either prior to the commencement of the arbitration or after the passing of the arbitral award. In the event an arbitral tribunal is not constituted under Section 11, the party shall have the right to file an appeal. Under Section 34, the patent illegality test will also apply to international commercial arbitrations conducted in India. To promote institutional arbitration, arbitral institutes will be empowered to constitute appellate arbitral tribunals, which will have the authority to hear objections under Section 34. This marks a departure from the current regime where two-tier arbitrations are subject to Section 34 objections in court. Interestingly, the bill proposes two options to address this conundrum of seat, venue, and their impact on jurisdictional issues. There will be statutory recognition of emergency arbitrators, the use of audiovisual electronic means for conducting arbitrations, and the execution of arbitration agreements through digital signatures. The bill also proposes changes to the constitution of the Arbitration Council. The Council will have the power to provide model arbitration agreements which parties can adopt, and model rules for procedures and guidelines for ad hoc arbitrations. The proposed amendments also provide for strict timelines, for example, 60 days under Section 11 for the appointment of arbitrators and for filing an appeal under Section 37, and 30 days for filing an application under Section 16, 2 and 3 at the preliminary stage. In this episode, I explore the key features of this bill and the implication of these amendments, if passed, and their impact on the future of arbitrations in India. Today, I have the distinct privilege of hosting Mr. Justice Rajiv Shakdher on the show. Justice Shakdher is the former Chief Justice of the Himachal Pradesh High Court and has also served as a judge of the Delhi High Court. Renowned for his unwavering integrity, erudite judgments, and above all, his profound humanity, Justice Shakdher commands immense respect across the bar and the bench. He is a staunch advocate for gender equality and is widely admired for his progressive approach to justice. I can personally attest that he is one of the most beloved figures in the legal fraternity. So thank you very much for being on the show and welcome.
Thank you. Thank you very much for having me on the show.
So before I delve into the intricacies and nuances of the bill, I just wanted to get your perspective. What do you think about this? Are they generally good, bad, or a mixed bag?
Well, my personal view is that it is in a sense a good measure that the legislature is looking at the act from time to time, because you've had amendments in 2015, you had the 2019-21. So when you get a feedback from practitioners, arbitrators, courts, you assess how the legislation is going forward. So if you were to ask me whether they should have taken a step for amending certain portions of the act, I am quite all right with that, because this is what we ask for, which is impact assessment of a legislation. So with that, what you really need to discuss with people who are involved with this entire process of arbitration is whether these draft amendments are actually going to make India a hub for arbitration. So there are some good parts, there are some parts that they need to go back to the drawing board and kind of discuss, re-engage with people and not be stuck with what they have presented, and that should be what should be the final outcome.
Right. So you'd mentioned that there are some good amendments. Should we start with the good news?
Yeah. So the good news is, according to me, is for example, the clarity that they have brought out in seat versus venue, because that's a very sort of troubled area for the courts.
Right.
It's good that by way of legislation we are clarifying it, and we no longer need to go back to those judgments if we can help it. So that's one broad good area. The other is actually giving statutory recognition to emergency arbitrations.
Correct. That's right.
So introduction of 9A is good,
Right.
and this is something that is going to help, again strengthening the arbitration regime. While we are on Section 9 or thereabouts, my concern is about the bill suggesting that during arbitration you can't approach the court, which is in a sense running away from a reality where you could have third parties in a matter where you may need to go to court
Right.
to seek sustenance for arbitration proceedings. For example, the easiest example that comes to my mind is invocation of bank guarantees.
Right.
Correct? Banks are never party to your arbitration agreement, but the final relief or the interim relief that you require
Right.
is to injunct the bank from honoring a request for encashment of a bank guarantee.
Correct.
So if you take that away, it could be very well argued that you can't injunct me even though Section 17 procedure is available.
Right.
And the object with which that during piece has been removed is laudable, but it could in certain situations tie the hands of the parties. So they need to think about it.
During the pendency of the arbitration.
My view is, if something is working, you don't need to fix it and proceed the way it is.
Yeah, absolutely.
Yeah.
So in the bill, they're talking about the Appellate Arbitral Tribunal. And just your thoughts about the constitution of the AAT. Do you think this is a good measure? And my concern around the AAT has been that there'll be two parallel structures in that sense. One which is the AAT, the other the court, and both have distinct procedures of their own. Do you foresee that this could lead to some sort of inconsistency, particularly in setting jurisprudence? Or do you think I'm overstating this because ultimately jurisprudence will be set by the courts?
No, I think your concerns are valid, Payal. I'll tell you why. If the purpose of having an appellate tribunal is to move towards an institutional arbitration, this perhaps is not the best way. That's my view. Others could disagree. Because this would only make arbitrations more expensive. Correct?
Right.
A company or an individual engages in arbitration, pays the arbitrators, then for the appellate tribunal again, forks out money. It's not a happy situation for parties. Arbitrations are, let's admit it, getting expensive. People are increasingly wanting to move towards courts. That is evident from the stance that the government of India has taken, and it is suggesting for various reasons, especially on account of costs, that you shouldn't have mandatory arbitration clauses in your contracts. And I can assure you that insofar as public sector is concerned, that's my, let's say, intuitive guess, that they are not going to take recourse to an appellate tribunal. So over a period of time, it may actually become a useless amendment. And then, of course, the other concern that practitioners have, you've written, I've read your pieces, I've read other pieces, where people say that it may then give rise to two parallel set of case laws. So you have the ATT and then you have courts, which is actually a recipe for more confusion rather than clarity.
Yes. So that brings me to my pet peeve, which is the patent illegality test. In the past, I've actually written that we should do away with the patent illegality test entirely, even from domestic arbitration, because the message we appear to be sending is that our arbitrators are not good enough for domestic, but they're perfectly okay for international arbitration. Bring your international arbitration to India. Now, with these proposed amendments, the patent illegality test is sought to be extended even to international commercial arbitration. I want to get your perspective. Do you think this is good to do because it's going to then become an level playing field for everybody, or do you think this is sending a completely incorrect message to the international community?
So I think majority of practitioners seem to echo the view, which is that introducing patent illegality vis-a-vis international commercial arbitrations is not a good idea. I completely agree with that. As I wrote when I was sitting as a judge in the Madras High Court, that if you see a picture on the wall in your house, you like to sort of adjust the angle. That's what happens to a judge, correct? He has a point of view, he's trained to intervene. Now, if a judge comes to a view that this conclusion, for whatever reason, is not good, after that he only rationalizes it and slots it in one of the areas where you can interfere. And as you go up higher in the appellate jurisdiction, the appellate courts then find it difficult to again intervene.
Right.
I agree with you, and I agree with those who say patent illegality should not be in international commercial arbitration. Should it be in domestic arbitration? The jury is out. I would go with the view, and that is if we want to make India a commercial arbitration hub, that maybe time has come to remove it from there as well. Because the three areas that we've left open for interference, which is, shocks the conscience of the court, is morally wrong, is not just, runs very close to a patent illegality test. Something which is not just is also, according to me, patently illegal and would shock the conscience of the court. So, yeah, maybe time has come to excise it from there as well.
So also what one of the areas that concerns me is that over a period of time, and particularly with Sangyong, the patent illegality doctrine itself has been expanded to include Wednesbury, which had previously been taken out, the supplementary report to the 246 Law Commission. Because now what has come in is irrationality and perversity. Now imagine this expanded patent illegality doctrine, which in and of itself I don't agree with, but that will be the test even for international commercial arbitration. So, but before I go any further, can you just explain why Wednesbury has no place in arbitration?
This is a principle which has been sort of, picked up from the administrative law jurisdiction and put into arbitration regime. It didn't last too long. Courts realized that that is not the way to move forward, because we keep forgetting, as I just said a moment ago, that you choose on your own volition a private adjudicator.
Right.
Once you've done that, as I believe, that you've made your bed, sleep on it, correct? So therefore the area for interference should be narrow, and the three areas that we just spoke about are
Right,
the
sir.
areas in which you should interfere. To say it is perverse and irrational, and then marry it with patent illegality, according to me, is really then going down a path where all kinds of aspects will be looked at by the court. Getting in gecko was Western gecko was really a bad idea, which the Supreme Court itself corrected. Now, any other attempt to get it in through back door by using these kind of tests wouldn't serve the purpose with which and the object with which the legislature has set out presently.
So one of the other things that has happened or is proposed to happen with this bill is Section 11 is sought to be made appealable. Now,
Hmm.
in the current context, if a Section 11 is dismissed, you have the option of filing a writ. There has been some criticism about the fact that if it's an international commercial arbitration and the Supreme Court appoints, then would the High Courts intervene in 226? But I still think no heavens fall, because ultimately, if you don't have an avenue to arbitrate, it's not like your rights are closed. You can always go to court. But this appeal system, my view is three levels of appeal. Don't you think this is going to delay the process?
No, I agree with you. I mean, you're just adding layers, which means right at the inception, there'll be several roadblocks. The one who doesn't want the dispute to end will immediately appeal for whatever it is worth. And in our system, you know how it happens. Because of caseload, you are not able to sometimes get to a matter which can be disposed of
Right.
in the shortest possible time. So, having another appeal layer is best done away with. It's not uh, something that I would vote for.
Right. So one of the good recommendations of the bill has been to give two options to the public in terms of how they're going to resolve this jurisdictional issue. So you'll recall that there in 2017 the Supreme Court had given the decision in Indus Mobile in Data Wind, where they had said that the parties could pick the seat, and wherever the seat had been picked by one of the parties, the that court would have the jurisdiction. But there were some scholars, including me, who had actually critiqued this from the perspective of it being in the teeth of Section 21E, because the sense under the current regime is that we must follow the scheme of Section 16 and 20 of the CPC. But I also had felt this was beneficial because it reduces the litigations around the jurisdiction issue. So firstly, I would like your view on what do you think, which side of the fence do you sit on, and then bring you to the issue of the two options that the proposed bill is talking about.
My view is that insofar as option number one is concerned, where they have brought about amendments by replacing place of arbitration with the expression seat, that's good.
Right.
Insofar as option number two is concerned, as I have understood, is that it takes you back to CPC, i.e., that courts where a contract is executed or the cause of action arises will be the courts which have jurisdiction. There are several people who say, and perhaps this is in line with what the Supreme Court said in Data Wind, is that the jurisdiction of the court for domestic arbitration should be determined by way of seat. Now, if you apply option 2, uh, it does in a sense take away the agency of parties who are involved in a domestic arbitration, not being able to choose a seat outside India for a variety of reasons.
Right.
Especially corporate entities may like to have a seat of arbitration as outside India, so that given the caseload that our courts have, there will be least amount of interference, and if there is, it could be resolved quickly. One would in a sense agree with that, because if parties choose to have a venue, or sorry, rather a seat outside India, there's nothing wrong with it. So in a sense, they have recognized what Data Wind did
Statutorily, yeah.
without there being let's say at that relevant point at that point in time space in the act. So I think it's all right, because parties should have that agency of having a seat outside India.
Right.
So I would agree with that view.
So, and what do you feel about the construct of being able to pick a seat if you have in international commercial arbitration, or Indian parties want to pick a seat outside versus two Indian parties wanting to pick a seat in India? Do you think that agency should exist, or should we be going purely by the principles of the CPC?
See, data wind, if my memory serves me well, was dealing with domestic
Domestic, yes, sir,
arbitration. It was not
entirely.
dealing with international commercial arbitration. So it picked up that principle from international commercial arbitration and embedded it in domestic arbitration. Obviously, there are two views. One view is no, if it is a domestic arbitration, as far as Indian parties are concerned, they should go by CPC. The other view is that you follow the data wind principle and that seat should determine. I think since data wind has now uh, lasted for several years,
Yes, sir.
it is good to retain that consistency and not just reverse it because there are people who say that it should not be done. It's worked, it's not harmed the arbitration regime interest. So I think it should go along those lines, and therefore that option should be available.
So it has also, I mean, one has to confess, reduced litigations around jurisdiction at the threshold.
Yeah, true. So,
So,
therefore, that's something that we must encourage,
right,
because on these aspects, these are peripheral disputes. The merits don't get adjudicated.
right,
And parties actually, at the end of the day, what do they want? They don't want these, legal arguments around jurisdiction, on appointment of arbitrators. They
Right.
want their
the meat
merits
of the
to be
matter, right,
to be adjudicated. They are
Right.
looking for a closure on their disputes.
right.
These are all delightful areas for lawyers, scholars, but it doesn't help
The litigant, that I
litigant at
agree
all,
with you entirely.
and adds to
yes,
the
sir.
costs.
So any misses in the draft amendment, something that you would have liked to see?
They're not catering enough for people without financial wherewithal. Reduce the areas where arbitration cannot be taken recourse to. For example, why shouldn't fraud be an area
Yeah,
which arbitrators should be able to adjudicate?
absolutely.
Non-arbitral areas, if you want to seriously deal with docket explosion, should be reduced, unless, as they say, it's an area which is completely in the realm of public law, or the award will be a reflection on rights in rem
Rem,
rather
yeah,
than rights in
personam,
personam.
yes.
These are areas that they should, the legislature should look at. So I would be very happy if they would bring in those areas as well. At least look at them. Fraud being one.
Sir, the 246 Law Commission, it just came back to me, had recommended fraud to be arbitrable. And in fact, if my memory serves me correctly, it is section 16(7) had been recommended in the 246th Commission for the inclusion of fraud to be arbitrable.
Yeah, so they can.
You just have to lift it.
Yeah, they have to lift it or look at it, discuss it,
Right.
and just bring it on the statute.
What about third party funding? Don't you think we require a legislation just to keep up with what's happening in the international space?
No, they could look at it. The only thing is they are wary of people buying litigation, in a sense. But if someone is funding it openly, and it is an accepted international regime, then why not? I don't see any problem in that.
So if we brought in a proper legislation, like countries like Singapore and I think Hong Kong that have done that, they could be adequate guardrails.
Yeah, so if checks and balances are there, like for example, when you are assigning debts, there are already legislations where, whether in common law or statutory, you can
Right.
assign debts. That's quite all right. But if you are in an area of speculation and you are funding a speculative litigation, then of course it's something, you have enough common law judgments which look at it very dimly.
That amendment that was brought in on fraud in section 36, shouldn't that be taken away?
Yeah, I think so. It would be in line with what we just
What
discussed.
we just discussed.
I
Right.
agree with you. There's another area which is something which is doable. Throwing out Section 11 petitions on jurisdiction. So what happens is I used to often tell litigators before me, listen, why don't you agree to an arbitrator? You know there is an arbitration agreement. You know you have to appoint an arbitrator. Now you're fighting in this court because this court doesn't have jurisdiction, but some other court has jurisdiction.
Right.
And especially when we are talking about e-filing, all that this person has to do is to remove the first page and file it in another court. And why don't we agree on appointment here and now, if other things being equal? Now these are little things that the legislature could fix, saying that Section 11, as long as it's in some high court,
Court, yeah.
and there is no other attendant area of concern, then that court should be able to appoint an arbitrator.
So if the arbitration regime continued to expand and there was consistency, by now, given the 2015 amendments, by now we would have had a full-fledged arbitration bar and a thriving arbitration practice in India. But
That's something that we've not been able to achieve. But hopefully we'll be able to. I'm not so pessimistic. I see some young and wonderful lawyers now, only being devoted to arbitration, and arbitrators actually taking up matters, during court hours, etc. So it's waiting to happen, but these are matters that we need to address.
so thank you so much. It's been an absolute pleasure.
Thank you, sir, for having me, as I said right at the beginning. But this is a conversation that needs
to
continue. The more people you talk to, the better results you will get, because iteration of a enactment bill is something that gives you the best outcomes.
Yes, sir.
Thank you.
Thank you, sir. This concludes today's episode of Navigating Commercial Disputes. Stay tuned for more in-depth discussions on the legal issues that matter most.